Last week, the Court of Appeal, by a 2-to-1 majority, ruled that the opposition's no-confidence motion was invalidly passed since it needed an absolute majority of 34 votes and not a simple majority of 33 to successfully pass. However, during a telephone interview with the Evening News, Justice Kennard posited that the spirit of the Constitution only speaks of a majority of all members of the National Assembly.
The Constitution is clear. It doesn't speak of absolute majority. It speaks about majority. And one has to interpret that in its ordinary context. I don't know where you're going to get absolute, you get half and you divide and all sort of nonsense. One looks at the Constitution, what it says. Does the Constitution use the word absolute? Definitely not.
The former Chancellor further pointed out that the framers of the Constitution and even those on the Constitutional Reform Commission, which included distinguished individuals such as Ralph Ramkaran and Justice Desiree Bernard, would have known that the words simple and absolute could have been inserted to qualify a majority, but instead they stayed away from that and defined that a majority to be that of all elected members of the National Assembly, which is 33.
You see, one cannot read in the Constitution what is not there. One cannot duly present where question arose about absolute and whatnot.
Last week's majority ruling of the appeal court had upturned Chief Justice Roxanne George's ruling earlier this year that the no-confidence motion was validly passed with the 33 votes, which is the majority of Guyana's 65-member National Assembly.
I'm in total agreement with the Chief Justice. There's no question about that. Her decision was a very strong one. Of course, the Court of Appeal by majority said something different. It was for the CCJ to make a final ruling in the matter.
Reporting for the Evening News, Vanu Manikchand.